Seconds counting down. Okay, it's 6:30. Let's call the Tuesday, August 26th, 2025 meeting of the Oxford Board of Zoning Appeals to order. We have an agenda in front of you, folks. First order of business is to welcome Jonathan Creech as a newly appointed board member, and I'm going to ask Attorney Kennard to swear him in.
Jonathan, why don't you come on down here? Some formalities here.
I'll bring my script.
Good. So if you raise your right hand. I, Jonathan Creech,
I, Jonathan Creech,
solemnly swear
solemnly swear
that I will support the Constitution
that I will support the Constitution
of the United States
of the United States
and the state of Ohio,
and the state of Ohio,
and will obey the laws thereof,
and will obey the laws thereof,
and that I will,
and that I will,
in all respects,
in all respects,
uphold and enforce
uphold and enforce
the provisions of the Charter
the provisions of the Charter
and the ordinances of the city of Oxford,
and the ordinances of the city of Oxford,
and will faithfully discharge
and will faithfully discharge
the duties of the Board of Zoning Appeals
the duties of the Board of Zoning Appeals
of the city of Oxford,
of the city of Oxford,
upon which I'm a member.
upon which I'm a member.
Thank you.
Thank you.
Congratulations.
I'll do it, we do that.
Welcome to the board, John.
Thank you very much.
Okay, we have approval of the June 24th, 25 minutes of the regular meeting. You have them before you. You've reviewed them. Do I have a motion to approve the minutes? So moved. Is there a second?
Second.
Second. Any questions, comments, modifications, revisions? Hearing none. All in favor indicate by saying aye.
Aye.
Opposed? Abstentions? Okay, minutes have been adopted. Next item on the agenda is the election of the vice chair.
Mr. Chairman, at this point, I'd like to formally resign as secretary of the board.
Okay. We have a request to resign as secretary. Mr. Chafin has been serving as the secretary. So now we have two positions open for election. First, we'll do the vice chair position. And I'll take a nomination from the floor.
I nominate Mr. Chafin to be vice chair.
There's a nomination for Steve Chafin to serve as vice chair. Is there a second?
Seconded.
It's been seconded. Any questions, concerns, comments, speeches of any sort? Hearing none, all in favor indicate by saying aye.
Aye.
Opposed, abstentions, congratulations, Mr.
Abstain.
Chafin, as the new vice chair. We still have a secretary position to be filled. Is there a nomination?
My name is John Creech.
There's been a nomination of Mr. Creech for the secretary of the board. Is there a second?
Second.
It's been seconded. Any questions, concerns, comments, speeches? Hearing none, all in favor indicate by saying aye.
Aye.
Opposed, abstentions, congratulations, Mr. Creech, you're the Secretary of the Board of Zoning Appeals. That's most of our housekeeping, I believe, and the main order of business today, we have no appeals, we have no variance requests, we have no applications. We do have some business, however. That business is amendments to the Board of Zoning, the BZA Rules of Procedure. There's also edits and some suggested changes in the zoning statute. Mr. Kennard will take us through the procedural recommendations, and I think Zach will take us through the proposals for the changes in the statute. We can make the changes tonight if we do so desire on the BZA procedures. However, the statutory changes, the changes to the zoning statute are going to be, they're going to require adoption by city council. We can, however, make recommendations, remain silent, or do whatever we want with sending that information up back to
That's the
council.
question I have, because Zach has pointed out we don't have authority to approve them, so why would we even be part of the process? Does the council consider our input important or not?
Yes.
Yeah?
Yes.
Okay, that's all I'm asking. So we should look at them, give our constructive criticism or whatever, and then, okay, thank you.
Let the minutes reflect that Balji has has
Aye.
appeared and is now
Apologize for being a few minutes
taking
late.
his seat at the meeting, so. Okay, so let's go ahead and move with the first order of business, amendments to the BZA Rules of Procedure. Attorney Kennard, please take us through those. We talked about these last meeting.
Yes, we did. So there's a narrative there. So there's a blend of things that I think that the rules were last adopted in 2021. Zach found some discrepancies between, I'll call them typos, really. There were some miscitations to the charter, and many of the changes are non-substantive, but there was also a desire to make sure that we paralleled the structure of the rules with both the charter and the code. Fundamentally, the city has been involved in a number of pieces of litigation over the years related to decisions made by the BZA. Many communities, Oxford being one of them, have historically conducted deliberations in open meetings. That is not required by Ohio law. It's very clear. The Board of Zoning Appeals acts as a quasi-judicial body. And so what does that exactly mean? What you really are adjudicators of fact. You consider facts, you apply standards, much like I think the best analogy that most people would have, unless you've served on a jury before, is instructions of law by a judge. In a criminal case, it's the one that I think most people just anecdotally would understand the process. The judge instructs a criminal jury on what the law is, and then the jury hears the facts and makes a determination of whether or not a person, based upon those facts, has committed a crime beyond a reasonable doubt. The standard here is a preponderance of evidence, which is a civil standard, but functionally you're doing the same thing. You deliberate to weigh the evidence that's been presented. That's the reason why witnesses are sworn under oath. And then you have the opportunity amongst the five of you, or whoever's present that constitutes the quorum, to weigh the evidence, applying the decision standards to determine whether or not to grant a variance or not. That is the quasi-judicial function. And that process can be clunky, is probably my best non-legal term. It can be awkward. And when a body is allowed to deliberate in open, it becomes part of the record. And sometimes those deliberations, when one looks at the record, make the record unclear. By way of example, someone's position may change during the course of deliberations. Someone may play devil's advocate in that role of deliberations. And so when the record is read back and reviewed by an attorney representing a party who a client did not get a variance, or a judge, or the 12th District Court of Appeals, it becomes challenging, because sometimes the deliberations and how someone might talk about how they're weighing the decision factors may be contrary to how they actually vote when you look at it on the record. I mean, can you imagine if criminal deliberations were conducted publicly, how that would affect the appeal process? And for that reason, the Ohio Supreme Court, in the Westlake case, which we cited in the notes, has repeatedly and consistently held that quasi-judicial deliberations are not subject to Ohio Opens Meetings law, and that they can be conducted in private. That's the reason why the board is required to issue a decision. And recognizing that Oxford has had a long tradition of having these deliberations in open meetings, as I was drafting proposed amendments, I recommend that the BZA adopt them. I think staff does too. But that was one of the reasons why we wanted to take into account a couple things. One was historically how we've done things. And the other reality is, not every case requires to go into a private deliberation. So the way that we've drafted the rule amendment, it allows the board to say, you know, this is a case where we want to deliberate privately, because there's a variety of issues that we want to discuss to make sure that we're clear about what we want to do. In addition to that, we think that it would be wise for staff to work with the board to issue, I think, more thoughtful, more comprehensive written decisions in cases that potentially a 2506 appeal would be taken. So it's very clear in the record how the BZA has ruled. And to actually apply findings of facts in a more formalized way, and then come back with a proposed finding of fact for the board to review and then adopt as a final decision to reflect the action of the board. I'll give you an example. In a bench trial in civil or criminal court, it is quite common for the judge to say, I will take the matter under advisement at the close of the evidence, when the case is all done, closing arguments are done, and then issue a written decision later. That gives the fact finder an opportunity to deliberate without the pressures of immediacy that sometimes the BZA might feel because of an application and an applicant's desire to find out immediately. But not all cases are the same. You know, I'd argue a variance on setbacks, size of buildings, those types of things, sometimes those get complicated. If somebody wants to come in and, you know, get a setback because of where they put their fence, I would suggest that that's a little less complicated. So fundamentally, I think that after a number of, I've only been the law director now, I think about 5 years, but I took over for Steve McHugh, who was here for over 30, and I'm aware of some of the history of some of the litigation that's been spawned because of the denial of variances. And we've seen repeatedly the pattern play out, that the record gets attacked because of the public deliberations, and it's not entirely clear why the BZA did what they did. So by instituting, I think, a more structured process that clearly is articulated in the rules, the public understands the process better, the board members understand the process better, and everyone will benefit from that. And I mean everybody, I mean the citizens, the staff, the volunteers who serve on the board. The final comment that I'll make is something that Zach's going to touch on, but the reason for the text amendment, the primary reason, is that there was a case from the 12th District that involved Oxford, where a decision of the Board of Zoning Appeals was reversed, in part because, and I've seen this happen, you may have done this in the course of your deliberations unwittingly, but there's discussion about, well, I remember another case that we had. Well, if that's not direct evidence, if that's not been presented in evidence, it can't be considered in your decision. You are literally required to stay within the four corners of the testimony that's been provided. So that's a precursor to when we get into the text amendment. We'll talk more about that in detail. But Phil, that's my overview on the recommendation and why.
Okay, I have, one, I generally support the recommendations of Attorney Kennard. I have one question, and that is, it will be our discretion to deliberate in private. We don't, it's not going to require us to do.
Correct, correct.
And I assume that it would be executed by a simple majority vote?
Yes.
It doesn't specify, I didn't see it specified.
Well, I
but-
think-
But I assume that
Yes.
would be the case.
Let me find where we are there.
Section 4, page 10, it does say majority.
Section 4, okay. Yeah, so 4A, when considering appeal or variance request, the board is acting in a quasi-judicial proceeding under Ohio law. Board deliberation by the public body when acting in their quasi-judicial capacities are not meetings and are not subject to the Open Meetings Act. Deliberations by the board are not required to be public.
Okay.
For this reason, the board may at its sole discretion upon motion, second, and approval of the majority of the board members present that constitute a quorum, enter into private deliberations and voting.
Okay. Related to the private deliberation, can the board bring in anyone it wants into that private deliberation?
Well, typically.
Under the Ohio Open Meetings Law, when a legislative body convenes into executive session, it can bring in anyone it wants.
Well, we'll need to qualify who you might be thinking about, but typically, and this is done on a case-by-case basis, depending on, I'll say, the contentiousness or perhaps the litigiousness of what may happen. You see this more in larger cities, where you see a big, for example, housing development come in, 600 units, and cities don't want it, the neighbors complain. The developers invested quite a bit of money, and the denial based upon the investment of time and energy, et cetera, et cetera. So the board is entitled to have a lawyer. As the law director, I can find myself in a conflict of interest depending on what that matter is. Generally, I define my role as the law director to help not steer, but be available to make sure the processes are playing out. I'm not here as an advocate. However, there can be times when there would be a lawyer who needs to be here on behalf of the city to perform an advocate role, much the same way applicants show up with their attorneys. If that situation were to develop in a given case, I would choose a side based upon whatever those dynamics are. So the city has in the past at times, based upon a recommendation of the law director, brought in outside counsel to perform that role. It's rare and it's unusual, but it could happen. So I think typically, as it relates to the law director's role, I think that I can go into those deliberations with you most of the time, but there will be exceptions to that rule.
Right. Okay, you've answered my question.
Right, but I
And
also-
that was my main concern, was that we could bring you in. However, as you say, there could be situations, and I've been in those situations where, as a board member or as a quasi-judicial body, we had an outside attorney representing us because the city attorney was representing the city.
Right.
Specifically in that particular contest.
But I want to make another point, though, as it relates to the question, just because I don't want it to be unaddressed, is that it would not be appropriate to take someone in who has testified. So, for example, a city staff member, not appropriate. Just in the same way, it wouldn't be appropriate to take the applicant in. They are witnesses. I mean, so if you think about it, this is a trial. And Phil, you are the board chair. You are the presiding judge, in effect.
Right.
And it's a body of 5 judges. Each of you think individually, but you collectively decide.
Yeah, my main concern was having either you or an outside attorney
Right.
in those private deliberations. Okay, so I think let's do this systematically, if not tediously, and go through Article 1, go through the rules of procedure of the BZA.
You may find some typos, by the way.
And,
I'm not the best proofreader.
Specifically where the specific changes, where there are additions or deletions, and we'll just do those in a fairly seriatim and tedious manner. So in Article 1, the Board of Zoning Appeals is established by Section 8.05, replaces 8.08. Do we need any explanation on that, Zach? I assume that's a typo that needs to be corrected.
No concerns.
Move the change. Any objections? All in favor?
Aye.
Aye. Okay, make that change, please, and Eddie, you'll be recording all these changes. Article 2, jurisdiction and function, according to Section 8.06 is the new text, replacing 8.09. Again, any issues? All in favor?
Aye.
Aye.
Opposed, abstentions, let's change that text. Move down to Article 4, meetings. Regular meetings of the board the addition is will typically be held in the Oxford Courthouse or other designated location. Special meetings may be called by the chair or by two members of the board, provided that special meetings must be called. And the new text is email or other form of written communication, and deleting the delivering of written notice thereof. Section 1 changes.
Question about
Yep.
that. What does this mean, written communication? Like, would that be text messages? What would that include? I'm a little concerned about that.
Well, my thought,
Letters.
first of all, let's say why the amendment
Yeah.
is being proposed, is that Zach pointed out that traditional written communication just isn't how people work in today's world. And I think that, I would assume that everybody is comfortable with email as the standard form of communication. I think, Steve, the concept there was you could hand deliver something to a person's house. I don't think it's something that's not intended to be as limited as US mail.
Okay,
Yep,
thank you.
okay. So Article 4, those text changes, all in favor?
Aye.
Opposed, abstentions, those are changed. Article 5, voting. Again, looks like a couple of typos, correction of section .805 will be added, deleted will be section 8.08, and there's a underscored hyphen to be eliminated as well. All in favor? Section 1 of Article 5. Opposed, abstentions. Make that text change. Okay, let's move down to Article 6, Section 2, action on application. The recommendation is the zoning administrator shall notify by regular mail the appellant, and that's recommended be eliminated, all owners of property within 200 feet of the property in question as to the date, time, place, purpose of the hearing at least 10 days prior to the hearing. And then also eliminate, then notice shall provide a form on which comments may be submitted to the zoning board, the Board of Zoning Appeals.
I'm happy to explain
Yep.
this one, Mr. Chair. And just to clarify, so anytime you see language that is highlighted in yellow, these are essentially like last-minute additions that I was able to kind of sneak in there for us to discuss as a group. So what this section is really addressing at its heart is the notification to surrounding properties. And this is a standard part of our process, no matter whether it's for Board of Zoning Appeals, for variances, or for planning commission cases. We always send out by US mail courtesy notices that include information on the case that's pending before the board. So we have methods by which we can obtain property owner information from the county auditor and mail those notices. In terms of notifying the appellant, whenever someone submits the application, there's going to be conversation, I guarantee you, ahead of time. There's going to be probably back and forth emails or phone calls or in-person visits. We publish the meeting dates and deadlines every year at the beginning of the year. So it's known up front, as long as you submit by a particular deadline, that you're going to be reaching a particular a regular board meeting date. So there's really not a need to emphasize that here. So that's why the appellant portion is struck.
Okay. And in the regular process of communicating with the appellant, they get as much information as you can give them,
Absolutely.
including whether or not there'll be an absence on the board, which they then have the opportunity to delay that appeal or that request for an administrative review.
Correct.
Mr. Chair.
Yep.
So I guess I'm concerned that we're deleting the requirement that they get mail, so the only notice is gonna be the sign.
Oh, no, we're not deleting that requirement. It's just specifying, notifying all owners of property within 200 feet. So our standard practice is to distribute the mailers, but it doesn't limit us to just that method of communication.
How else would you do it?
I suppose if someone saw the sign and they wanted to, stop by and inquire about the case, we would be able to provide them whatever public documents were available.
I really just think we need to make sure that this language protects residents who are affected by these potential changes. They know about it. We're going to remove the requirement that the sign not be legible from the public right away. I don't understand that either. I would like to have more opportunities for the public to give input, not less.
Well, we've got three. We've got the notice that's sent individually to the property owners within 200 feet.
That's
Which-
protected by these changes. 'Cause I didn't
Then
understand
we
that.
then we have the signage that goes up, and
Right.
then we have the public notice for the public at large as well.
That's only by the website, or, I mean, there's no other, you don't publish in the paper.
Yes, we do.
Well, that's correct, because
Yeah.
we're not required to do that
Right,
anymore.
I'm just saying, it seems kind of limited if we take away the opportunity, you know, I'm just not clear the way the language is, we're gonna be mandated to give regular mail. Are you telling me you believe that this protects the regular mail notice to adjoining property owners?
I'll say this, that the state legislature, I think about 4 years ago, maybe 5, I think that Oxford, maybe it's long enough that it was the last charter review by the city, but the state legislature eliminated the need for the use of US mail as a required form of notice. It can be among the bundle of forms of notice that one can give, but I think it's a reflection of the modern world that staff has an obligation to give notice. The failure to give notice could create a procedural defect if there were a challenge later on. I'm not sure that there's a better way
And the-
between those three. I mean, there's kind of a
and
fail-safe there. You've got
Right.
three means to get notice out there.
Right, and the statute doesn't require notification, does it?
It does.
And as technology is bloomed, so to speak, it's sort of a, you email, then you have to send out another letter. It's kind of burdensome, I believe. These state legislators across the country did that. It's like, most people get their information from email. The fact that we're doing mail, snail mail, and email, and all those other things is just kind of an added-on thing, notice. And I think that
Well,
it's fair enough.
It still requires, it says shall notify owners, so there's
It
still gonna be.
doesn't say how, that's my concern.
Yeah, it doesn't say
I
how.
mean, you could go down the street and have a sign, but no one's gonna pay attention to that. I mean, I just think we need a formal process, so the property owners, adjoining property owners can know about these hearings. I don't like the idea
I'd be
we're
fine leaving
pushing the sign
the
out of
sign
the public right away. I think that's wrong. And I think we should
Leaving
say,
by
we
regular
have to give
mail.
notice by mail.
In there.
Would mention of a personal communication of some sort,
That'd be
or
fine.
just mention of means of private communication be
If
a
some
suitable?
documentation is provided so that we.
Shall
know.
notify all owners directly.
Okay,
Directly is good.
How about that?
I'll take that.
And then it might be through email, they might knock on the door, they might do
Okay,
something.
okay.
The zoning administrator shall notify all owners of the property within 200 feet directly. So,
Okay.
that takes care of that.
You okay with
Good?
I'll move that that be approved.
I'm not sure that I would support that particular language. I think my preference would be to just simply leave by regular mail in the text, since that's our standard practice.
I'll live with that too. Thank you.
So,
Well, I mean, certainly because we're not going to necessarily have emails for people that we don't know.
That's true.
Right.
And-
Regular mail.
We only
and
have
what-
emails for
and what
rental
What
properties.
defines their proximity to 200 feet is an address, so in this instance, regular mail probably makes sense.
Can I ask you now, I haven't heard of any adjoining property owner complain about not getting notice since I've been on the board. Have there been instances where that's happened, in your experience?
I have seen situations where somebody said, I didn't know it was happening, and they didn't see the mail, they didn't, I mean, it's happened.
Well, sure.
I mean, we've all had personal experiences where we didn't see something that somebody said that we got in the mail, whether they didn't.
Yeah,
realize
I
it.
think right now, getting the mail is one of the least effective ways to
Might
get
be.
communication to anybody right now, just how. most
Yeah,
of us
well,
don't
until we
look
all
at
have
the mail.
emails, and we know the email was received.
Yeah,
with the
I think
receipt.
personally, I like directly because
I
it
do
gives
too,
you
as
the
well.
option to do it by mail, gives you an option to actually knock on someone's door if you get a return receipt, return to sender. So my preference would be directly. That way
I'm
we're-
good either way.
That way we're
Yeah.
handling, we give the
Zach,
option.
what I
of
would say
both.
is if the word directly were used, that would give staff the choice.
Right,
Yes.
Okay. If that's the interpretation, then
Yes.
I'm
So-
fine.
That's what we're
Yeah.
saying, if it's
All
your
you need to say is
interpretation.
if there was a form of an attempt,
An outreach.
an outreach.
right.
Yes.
It could be hand-delivered by
Or
a
not,
city,
would be better.
city personnel if it's a small number of property owners. So notify directly all owners of property within 200 feet. Right.
Thank you.
And then the attending sentence, the notice shall provide a form on which comments may be submitted to the Board of Zoning Appeal. Does the notice clearly states that they may provide whatever to you or through you or to the board?
It states the time, place for the hearing. It states that those who have standing may attend
Okay.
and provide testimony. So
Okay.
it keeps the testimony contained to the
Got
hearing.
it, got it. That way we're not making up a form that could be subject to a contest because it was improperly designed.
That's fine.
All right, so in section 2, paragraph A, there's a final piece down in the second page there. The signs shall state that the site is subject of public hearing and shall list the type, time, place of hearing, and shall be legible from the public right-of-way. So you don't want them legible, Zach? Is it?
That can't always be guaranteed depending on what site is under consideration.
Yes.
But- And the signs I've seen are really not easily read. You've got to get out of your car, stop and get up there and look at them. I don't know if that can be improved, but I definitely don't like the idea that we're taking that public right-of-way issue out. It needs to be some way, because people might miss the mail. When the Dudley property, I didn't know, and I wasn't interested, I wasn't within 200 feet, but I was still interested, so I went and saw the sign. So I want to make sure that sign is as legible as possible.
I think the sign is probably the least effective.
Can we leave the legible language in there, shall be legible?
Well, I think what it does, well, I'll ask Chris on this. Does that create an issue that someone might contest something because the sign wasn't legible and a decision was made?
We could define what legible means. just
Well,
like
yeah, we could, and we could
Like
make
10
this
point-
cumbersome and.
10 point or 12 point,
Well,
like they do in a lot of
so
other.
legible means this or this. I think that's micro.
Yeah.
I think that's minutia. I think that Sam makes a great point. How do we know if somebody sees it to begin with? The issue is by posting the sign, people will see it. I think the signage is big enough that it's presumed to be legible, and if it's something that's in your neighborhood that you have an interest in, you will take the time to understand what the sign says.
My experience is word of mouth travels very quickly and that everyone knows rather quickly, so I don't have a problem with eliminating that.
While we're on this subject, though, I see this language in here about removal of the sign. Have we had issues where people have removed the signs?
Remove them on their own.
Or somebody just wanted to be mischievous and remove the sign? Say a student.
I'm unaware, but it certainly probably has happened.
I'm personally familiar with
You're
an instance
familiar
of
with
that.
one?
And
You know,
Told the
so
property owner
if,
not to.
if the signs
not-
get removed, we don't know who removed them, we can't do a lot about it, but it might affect the ability of people to be aware of the hearing.
Yeah.
Here's literally every possible scenario you could think about,
I know.
Steve. So, I mean, we can't,
Remove, I don't have a
Yeah.
problem with that.
Okay,
So, section A, then those changes, directly eliminate the notice shall provide a form and eliminate shall be legible from the public right of way. All in favor, indicate by saying aye. Aye, opposed?
I'm
Abst-
abstaining.
Abstention, one second. Okay, paragraph B, the zoning administrator shall transmit to the board. And you're eliminating approximately 1 week prior to the meeting or as soon thereafter as possible, the appeal or variance application and all papers and information required are necessary for proper hearing of the matter before the board no less than 4 days. I have a problem with that.
So do I.
Well, Zach should probably explain what the challenge there is, why this discussion came up. And it's not, we're not committed to it, but there was a practical reason.
Well, since starting here with the city of Oxford, it's always been, packets have been published on Thursdays before the meeting. It used to be that meetings were actually Wednesday nights, not Tuesday nights. We follow the same protocol for planning commission. It's a Thursday publishing prior to a Tuesday meeting. If you would like to change that to a week prior, I'm okay with that, but I think the intent here is to provide a minimum number of days, 4 days. Right now, what it says, it's 1 week prior to the meeting or as soon thereafter as possible. You know, with this particular packet, unfortunately, it went out even past our normal day of Thursday. It went out on Friday. We did the best job that we could to get you the information as quickly as possible. And yeah, I think it's generally just good work ethic, and I definitely, you know, subscribe to that philosophy. So
Here's my recommendation. Zoning administrator shall transmit to the board no less than 7 days prior to the meeting the appeal or variance application.
So we're gonna delete the,
Yeah.
or as soon thereafter as
No,
possible, which
yeah,
is
we're
kind of a
repla-
loophole that's been used.
I'm recommending my language. The zoning administrator shall transmit to the board no less than 7 days.
With the other-
Prior to the meeting or as soon as thereafter. I'm sorry, just prior to the meeting, the appeal of the variance application and all the papers.
And I'll move to accept that.
So all you're doing is changing 4 days to 7 days.
Yeah. I'd like 10 days, but I'll go with 7.
The only thing I'll say is that there are times when an applicant will want to bring something else in, and it could have the effect of delaying. I'd like to see something that allows for some flexibility in the event that there's something that unforeseen happens.
Well, can't the applicant come to the hearing and present that new evidence?
Well, the intention is that you have everything in advance, that staff has that evidence as well, because staff is preparing a report based upon that. And so in the context of quasi judicial due process, we have due process that plays in three areas. Staff is required to give due process, but they get it too. The applicant gets, but they have to participate, and of course, you are the ones who decide what the due process is and how it plays out. And for you to do, if you're interested in 7 days at least to have it, showing up and supplementing the record is not ideal, but you're also want to be fair in your role. So, and if you have 7 days strictly in there, what happens if you don't get it within 7 days? Then we're gonna get into the issue of the cancellation of a meeting.
Yes.
Or that matter.
Yes,
Just
I don't have a
in-
problem with the no less than 7 days. I want to have the 7 days to ruminate, to look at it, to visit the site. I might make a couple of visits. So,
And if that's.
and
acceptable-
if something comes in late, you're going to know about it before we do, number one. So it isn't like you're going to be cut out of it. And they can present it at the hearing. I don't see that as being necessarily a defect. And it might be something that does require a extension or a,
Can we
A rescheduling.
pass on this one for just a second, and then let's talk about that in the context of when we get to the cancellation of meeting component.
okay? Okay. Go to section 3. Section 3, hearings. Item L, the Board of Zoning.
Well, we had C there, we added the word minutes, it was at the.
Oh,
top.
yes, I'm sorry. I didn't see that. My glasses. So the applicant shall limit his or her testimony to 15 minutes, including any information presented by his or her duly appointed agent or attorney. What's magic about the 15 minutes, other than expediency.
Better than ours.
Is that not being followed now?
Oh, no.
No, it works, it's just the word minute, the minutes was missing from there, it was a typo.
Okay.
An omission of a word that everybody understood to be there implicitly.
Yeah. All right. Everyone okay with adding minutes?
Okay.
All in favor, indicate by saying aye.
Aye.
Opposed, abstention? All right. Section L, Board of recommendation is eliminate the wording, the Board of Zoning Appeals shall have prepared minutes of the proceedings containing a report of all evidence admitted or proffered by the board.
I deleted it because I don't know what it means.
Yeah, I'm not sure what it means either, since there's other references to the board keeping a record and so on and so forth. So we'll eliminate that, all in favor?
Aye.
Opposed, abstentions. Note the re-lettering as a result of that change. So M becomes L, N becomes M. Everyone's fine with that. All right, shall not. Under new M, such postponement shall be granted or denied in the sole direction of the board, and any postponement of the hearing once commenced shall not be for more than 45 days, except with a written permission of both the zoning administrator and the applicant. Shall not be. Is that another one of these where the word was missing? Okay.
Yes, indeed.
So, all in favor of fixing that defect?
Aye.
Opposed? Abstentions. O, P, and Q, all that wording is is recommended that it be eliminated. Zoning administrator or board shall file, well, you can read it, with the minutes, exclusions, facts, at the conclusion of the hearing. This is,
Is all that covered under section 5C?
well, there's numerous references in other sections where we keep a record of proceedings, issue a finding, facts, so on and so forth. So I think it's just redundant and,
So between section 5B and C, all that's covered? Is that what we're saying?
That was the intention.
yes. So sections O, P, and Q, recommended those be deleted.
No objections?
All in favor?
Aye.
Aye.
Opposed? Abstentions. All right, section 4, this is new text. Deliberations. A, when considering appeal or variance requests, the board is acting in a quasi-judicial proceeding. Under Ohio law, board deliberations by the public body, when acting in their quasi-judicial capacities, are not meetings and are not subject to the Open Meetings Act. Deliberations by the board are not required to be public. For this reading, the board may, at its sole discretion upon motion, second, and approval of the majority of the board members present that constitute a quorum, enter into private deliberations and voting. So the voting would be done in private as well, Chris?
Yeah, well, in private, essentially, you're polling your group, then you would come out and announce your decision, depending on how we decided to deal with the written decision.
But and again, I'm kind of comparing it to the Open Meetings Act and executive session. You can discuss, you can.
Yeah, but this is not, well, we're not an open meeting.
I understand, but I just want to understand the techniques. So a vote can be taken in this private deliberation.
Correct.
Will it then be reaffirmed once we come out in public,
Yeah, yes, it
Okay.
would be, I would say, announced.
announced?
You'd be like a judge announcing the decision of the body.
Announced 3 to
Correct.
2
The jury comes out,
by a
they're
vote
taking
of,
the vote, and you would announce your vote.
by a vote of 3 to 2.
Well, I would.
Poll.
I would poll.
Okay.
Your group.
That's what I'm trying to get at, is that on the record, we have the individual
So everybody knows
votes.
how everybody voted,
Right.
yes.
I would say, but is your recommendation stemming from the fact that we've always had it open? Because I would rather, because we're not a legislative body, because we're not making legislation, because people are very litigious also, and picking apart what we say, and Ohio law does not mandate at all that we have it open. And things can be very much interpreted. I sit on a body, I sit on a board that has to have everything open and things are picked apart. It would be my feeling that we should have it all in private, and then come out with deliberation, especially from the fact that we have
But
people
what hap-
in varying degrees of how long they've served in this body. And I think having it private is a wise thing to do.
So, and I'm not disagreeing, I'm just trying to understand now. So hypothetically, board goes and deliberates, and it's a 4-to-1 vote to approve. Are you thinking then the board would come out and announce the decision as a 4-to-1 vote approving without polling the individual members?
Yeah, that's what I'd like.
Yeah, I mean, if it is 4-to-1, that individual that was the one that either abstained or voted against, they should be able to say why, you know. But as far as the deliberation goes, the back and forth, I don't believe that's necessary, and I also think that it's more fraught, and open the city up for a lot of things that's unnecessary. And we don't make the rules, we narrowly interpret the rules. And that's, if we were making the rules, if we were making legislation, if we were doing things like that, I absolutely have everything open. That's not what we do. And that's why I would have a concern. Having
Well,
all
what I
our
would say
deliberations
is,
open.
and I'm not sure what I think about it. I'm just, so my comments are not pushback, they're just to simply say, if your appeals body, akin to a court of appeals or the Supreme Court, when that decision is issued by those bodies, we know how they voted. So that's kind of the rationale that I
Yeah,
apply to the
Well, they go
thought
in,
process.
they go into chamber
Right.
and have their debate and then come out and have their.
And then they are polled.
But each person on the board says, I vote yes or no.
Right? I don't have a problem with this, I support it fully. I don't have a problem with what you're saying. And I see the same issues that you see, Matt, and that is that deliberations in private are gonna be, I think, a lot more constructive and well-reasoned, and less hurried and more complete, I think, in looking at all the evidence and testimony and documentation that we receive.
And we're not making
But-
the rules.
but-
That's the.
Well, here's what I think.
But coming out and then even taking the vote in that private is fine. But when you come out, I have no problem. In fact, I expect that we would indicate how we voted.
So let's talk a little bit about process here, because I confess that I'm not exactly sure how some of this would play out. But again, my hypothetical, it's a hotly deliberated request. In deliberations, you privately vote 4-to-1. You come out, whether you're individually polled or not isn't really the point here, but you announce a 4-to-1 decision. All that does is inform the applicant that they got what they wanted or they didn't, but it's not a final decision
Right.
yet, because it's practically impossible. We cannot write a decision that night that
Right.
would reflect the findings of fact that you've made. Within the deliberations, if I were in there, your lawyer, whoever it is, particularly on a complicated case, somebody's gonna have to draft a proposed opinion for you to adopt. And what I would envision would happen at that point is, when you would come back to the next meeting, you would take that opinion and it would be edited as you saw fit. I mean, and this is where it gets really clunky, but you talk about the US Supreme Court or any Supreme, they circulate the opinion privately until they all agree that it's final, and any dissents get added on. I don't think we're gonna see dissents in the BZA, but as you're a volunteer body,
It might.
I'm envisioning that there would be a draft that would be circulated to you. You would come back to the meeting, prepared to discuss and deliberate the findings of fact that you want to have in the record that reflect your 4-to-1 vote, if you announced it after coming out of deliberations. The other alternative could be that you deliberate, you come back out and say, we're going to draft findings of fact, and we will announce our decision at the next meeting. I mean, these are all the variations that we can have. I don't know what the right answer is. All I'm trying to do is.
But that
empower
language
you.
allows us to do that, doesn't it?
That's how
I mean, we can
try-
come out of the deliberation and say, we have made a decision, we'll be submitting, we'll be providing you with a written,
Right, exactly. That's the intention that I tried to give you the flexibility, given
And-
the complexity of the case.
I think this is fine, I understand it completely, I think it does what we want it to do in terms of having an honest, open, and frank, and full, and quality deliberation, that sometimes board members may feel are, they're blocked from doing in the public, and the Ohio Supreme Court says we can, so I'll move this language the way it is.
I'll second.
All in favor?
Aye.
Opposed? Abstentions? All right.
All right, there's one typo in 4A, there's a small b for board in the third line from the bottom on the right. Well, we need to capitalize that.
So noted, make the change. Section 5 now, 4 becomes 5, old 4 becomes new 5. Following deliberations as opposed to the hearing. Part B, board shall keep a record of proceedings, all records of proceeding, finding, determination, action of the board shall be filed in the zoning administrator's office. Chris, this covers, I think, a lot of Steve's questions about record and so on and so forth. So, section B, all in favor?
Aye.
Opposed? Abstentions? It's adopted. New C, the board shall issue a decision clearly stating the finding of facts upon which its decision is based. The board may issue a decision orally memorialized by a letter from the zoning administrator or the zoning administrator's assistant, sent within 10 days after the board votes. In its sole discretion, the board may continue its deliberations to the next regularly scheduled meeting to approve its written decision that shall be signed by the board chair journalizing the board's decision.
Okay, so here's the thought process of how this would play out practically. In the hypothetical, fence setback variance request. Whether you deliberate in public or private doesn't really matter, but you approve it that night because there's no reason to go into formal written decision. We have a form that's easily checked the box. You adopt staff's findings and recommendations. And the reality is, I'm unaware of any citizen 2506 appeal in Oxford's history, although I'm sure that it's happened. But that's a rarity. Most of the time, the appellant gets what they want, applicant gets what they want, if they get it, they walk out happy. So they don't really care
Right.
what that is. So I think a form notice contemplated by this provision makes sense.
Got it.
Then again, gives you the option to bring back more complex cases for the formal written decision that might become the record if it's reviewed by a common police court judge in Butler
And it
County.
streamlines the less contentious instances, yeah. Okay, so, new section C, all in favor? Opposed, abstentions, it's changed. New E, no order of the board permitting erection or alteration of a building or use of a building or premises shall be valid for a period longer than 12 months. It used to be 6 months.
I can offer some
Yep.
explanation on this. So this essentially just maintains consistency with the language that's currently in our zoning code. So when we're issuing approvals for variances now, we're stating it's
12 months.
good for 12 months.
Right.
Yes.
Yes. All in favor?
Aye.
Opposed, abstentions,
Abstain.
noted. Final is simply changing old E to F. That's a notation, and let's have one final vote on the revised procedures. Just button it all up, so.
So we have to go back, and I thought there was something in there, we've got to go back.
Oh, yes.
For the
Yes.
4 days or something.
We've
Subsection
got to go
B.
back to subsection B on page 3 at the top, which is
Yep.
subsection 2B, which really went to the 7 days. That, you're the body, my view, you're a volunteer board. This is what if that's what you want, then you should get what you want as volunteers.
I'm gonna, we adopt the language of 7 days instead of 4.
Not less than
I-
7
No,
days.
that's-
If I could say one more thing, I do think it's on a Tuesday, right?
4 days is the Friday prior. And so, to me, that's plenty of time to do it. I will
For me,
abstain
it's
from this
not.
vote.
It simply is
That-
not.
Then that's fine, but I just wanted to say that, I think 4 days
Sometimes
is
there's some
fine by me.
complicated legal stuff that I gotta look at and make sure the code jives
Gotcha.
with, what we're
Yeah.
doing.
How would you feel if we added some verbiage that said, in the event supplemental evidence for the board is presented, or whatever you would call that, additional information didn't make it into the packet, to put people on notice that that could cause the hearing to be continued?
Is it irregular for supplemental material received at a later date to be offered in the form of an addendum or an addition sent out afterwards?
It happens. I mean,
So what-
particularly when you have an individual who doesn't have an agent or lawyer who's watching the procedure. You have to just, a citizen filling out the paperwork and, oh, I forgot something, Zach, and 2 days before the hearing. I mean, we accommodate for sure. And again,
Well, give us some language there, Chris. The zoning administrator shall transmit to the board no less than 7 days prior to the appeal or variance application, and all papers and information required and necessary for proper hearing of the matter before the board no less than, that should be also 7 days. So 7 days in both.
where's the other change? I'm missing it.
But you're suggesting, yeah, you're suggesting another,
Oh, okay, so my sense would be after, no less than 7 days before the hearing, in the event additional information.
So they could reschedule within the 7-day period. I mean, if you had the rule, they can't bring anything forward, if it's past 7 days before the meeting, if that's the rule. And if they happen 2-3 days before the meeting, 4 days before the meeting, have something, they could reschedule, right? Because, but we're just saying that you can't be anything added to our information, our packet, if it's within that time period.
In the hearing, so.
Well, it could be interested in the hearing, I get
It could be in the hearing, but the staff isn't able
Is
to.
that much of an
It
issue?
puts them in a
I mean,
disadvantage.
I could be over lawyering and thinking.
I-
yeah, I think the opportunity for both staff and the appellant to add and bring additional relevant information, evidentiary information in the hearing, I think is available, and, or even a request to postpone.
Right, they can postpone it. If we were like, there's not enough time,
I mean,
we
we
can postpone.
We've postponed meetings
All the time.
all the time. So I think it just might be
Okay.
it doesn't preclude, I mean, the instruction here is more for the
You know
zoning
what, if it
administrator.
doesn't work,
Shall
you
transmit.
can always go back and amend the rules.
Right,
Find out again.
right.
So just change 7 to 4, and then then.
7,
7.
not less than 7.
4 to 7, I'm sorry.
Not less than 7 days. All in favor indicate by saying aye.
Aye.
Opposed, abstentions, it is changed. All right, now, let's have one final motion on the rules of procedure as changed and edited.
I have one question about these appendixes that are being added to. Are these appendix to our rule changes?
Yes.
Okay, well, my concern would be then under that 113902C2, that decision standard, isn't that going to require the statutory process, the legislative process, before we can adopt it?
That's a good point, Steve.
I think it does.
I think you're right. We'll make it simple.
Yeah,
So I would move
So
just to
here's
strike
what I
that.
would say, is that you could adopt the current rules without the change in Exhibit A, and then we can go back after the council, if they decide to do the text amendment, then we can insert that in at another meeting.
I would move so. I would move that we adopt the appendix A with the deletion of that language that says, unless evidence is introduced in the record for purpose showing variance, previously granted or denied, or similarly situated property, and then come back once the
yeah,
legislative.
that goes through council.
Yeah,
Right.
I think that's a good
Okay.
point.
So forget Appendix A then right now.
We can adopt it. We're
You've
just-
amended the rules, but for Appendix A.
except for Appendix A, correct. All right, so the rules and Appendix B. No, yes. A and B. One final vote. All in favor of the amended rules of procedure, indicate by saying aye.
Aye.
Opposed, abstentions, they are changed, they are adopted, thank you. Okay, Zach?
Yes, so when it comes to the remaining pages in your packet, section 1139.02, these are actually changes that were submitted by Mr. Connor. And I just simply clarified in my memo that, and I think you already clarified, Mr. Chair, that the changes that are proposed here would be to the actual statute, to the
Right.
codified ordinances. So the BZA doesn't have authority to make those changes. That would ultimately go through the text amendment process, planning commission recommendation, city council decision. So just consider this supplemental information, but you're certainly welcome to discuss and.
Could you just give us the bullet points about how those would interact with our procedures and?
I'd probably turn that over to Mr. Connor to explain.
Yeah, so, again, looking at section 2 here, 113902, C2. When I first became a law director, and I was talking to Sam Perry, and that provision was in there that said you can't consider any other variances. I couldn't figure out, it just struck me as wrong, but I didn't know, I couldn't figure out why. And Sam and I talked a little bit about it, and he wasn't sure how it got in there. I don't know when it got in. I think it came in as a result of the Conrad case, but they didn't put in the rest of it, because and this came to light in one of the pieces of litigation, that how can there ever be a disparate treatment claim if you're not allowed to hear evidence in the record of a similarly situated property where a variance request is made? It's impossible. And so it became apparent that there was a clause that was missing from our code. And the other reality is, staff routinely presents in its packet evidence of other similarly situated properties. So
Yeah.
at the same time they're presenting evidence, you're not allowed to consider it. I mean, it's just, it's illogical. So that relates to the unless evidence is introduced into the record, and I think that the part of that is it clearly makes applicants aware of that as well, particularly the applicants who aren't represented by a counsel or an agent. Now, as it relates to the change, removing the word unreasonable, unreasonable in this context is a legal word that lawyers will tell you what it means, but it still depends on facts. So the word inequitable, I think, is a word that Steve McHugh and I kind of batted around, and that's where we landed. We felt that that was a word that a lay board could apply with reasonable clarity, coupled with and prevent substantial injustice, another way of saying something that sounds in fairness, based upon the evidence presented. And I think it's as simple as that.
Okay. So, do we want an official sense of the board that we support these
I would
changes?
do a motion and second that says motion to make a recommendation to the city council to approve the text amendment as recommended by the BZA.
May I ask a question?
Yep.
So is this the new language we're putting in here specifically because of the Conrad case? Are there other statutory or other precedents that you're looking at?
The Conrad case is about 90% of it.
Okay.
And I,
Because
but,
I've read it several times, and it's a little bit confusing. Wouldn't you admit the whole process was a little bit complicated? are members of the council going to understand this?
Oh, yes, because of the litigation, I had significant discussions with city manager, city manager in San Perry, who were involved in we were involved in a mediation. But here's another reason why it's so important, and to me, this is the prevailing reason, forgetting about the Conrad case. I have sat in deliberations with bodies sitting quasi-judicially. You may or may not be shocked to know how often they will start talking about things that weren't introduced into evidence. And I have to tell them, did you hear any evidence on that? So this is really meant to help you as well. So that somebody, like the Conrad case, doesn't sit up there to say, hey, I remember a variance that was granted here. Well, one, is the variance even related, similarly situated as a property? So I think that it's really important, even if the Conrad case didn't exist, I would tell you this is a positive text amendment for the board.
Okay.
Oh, and I'm sorry, one other thing. The other part about it is because now you have the option to deliberate privately, I think it helps prevent private deliberations and the board members from losing their way in deliberations as well,
Yeah, Yes.
which is probably even a paramount consideration, because that can easily occur, and then a substantial injustice would arbitrary, unreasonable, capricious decision.
right.
Okay, can I ask one more question? I'm sorry, this might be stupid, but the decision was issued in 2016. Why has it taken 7 years for us to catch up with this?
Because before my time, I didn't even know the case existed until we started briefing a case, and then started thinking about it. But interestingly enough, from what I can tell from the text amendments, that text amendment was put in there before the Conrad case.
Sure.
But nobody ever appealed it in the Conrad case. So, I mean, there's a whole series of, I don't know how we got here, I just know that we gotta fix it.
No one on this board was on that.
And I wasn't the law director, so we all have plausible deniability.
Everyone's
But
hands are
but
clean.
seriously, I think it immensely improves the code, and I think that we have an obligation in our various roles to make sure that the public's interests are protected in all variety of ways, and I think that this accomplishes it.
Can I have a motion that the BZA has reviewed the recommendations of council and staff for the ordinance and fully supports the changes as reviewed?
So moved.
It's been moved and seconded.
Second.
All in favor indicate by saying aye.
Aye.
Opposed? Abstentions? You have a sense of BZA on that. There is no other business.
Well, the one thing is, since we might vote for the record, there were no audience participation, so there was no public comment to be had.
There was no public comment. So, it was a public, but that public has left. No other business before the board. I'll entertain a motion to adjourn. Second? All in favor?
Aye.
We're adjourned.
Thank you.
Less contentious than I was going to be. I said less contentious than I thought it was going
Good, guys. Well, thank you. I'm glad you caught that much stuff. I apologize.
to be. Good luck with campaign. I mean, I might have screwed up.
I was so focused.
thrown together, so.
Yeah, well, there was a couple typos in there, but
I'm no longer on the board.
I used to be able to.
Oh, and
I resigned
commentary.
because of
Yeah.
I
differences
didn't
with
even
the chair.
Sure, I just copy paste.
But I'll put a good word for